Welcome back. You're watching Court TV Live. It is time for the daily sidebar. Testimony finished up for the day earlier, finished up for the week. Judge Cahill said the case is ahead of schedule and dismissed the jury early before the holiday weekend. Before the break, Minnesota Police Lieutenant Richard Zimmerman was questioned about how much force an officer should use when a person is handcuffed.
You saw then Officer Chauvin with his knee on Mr. Floyd's neck, correct?
Yes.
Would you call what you saw there a use of force?
Yes.
And did that use of force continue until the ambulance arrived?
Yes, it did.
Was there any change in the level of force being used until the ambulance arrived?
No.
And what do you think about that use of force during that time period?
I'm sorry?
What do you think about that use of force during that time period?
A little vague. Could you limit it to the time frame?
Right. Okay. So, based on your review of the body-worn camera videos of the incident,
Yes.
and directing your attention, to that moment when Mr. Floyd is placed on the ground,
Yes.
what is your view of that use of force during that time period?
Totally unnecessary.
Let's bring in Chanley Painter, Julie Grant, and Michael Ayala. This was the second half of the 1-2 punch from the state. The first one was Pluger. Yesterday, he testified basically the same type of thing, saying that restraint should not have been used when George Floyd stopped resisting. Take a listen.
Based on your review of the body-worn camera footage, do you have an opinion as to when the restraint of Mr. Floyd should have ended in this encounter?
Yes.
What is it?
When Mr. Floyd was no longer offering up any resistance to the officers, they could have ended their restraint.
And that was after he was handcuffed and on the ground and no longer resisting?
Correct.
Thank you. I have no further questions, Your Honor.
All right, Michael Ayala, what did you think of Zimmerman when you attach him to Pluger as well? Your thoughts on their testimony?
Yeah, you cannot deny, Ted, that strong testimony really helping out the prosecution's case. I mean, they're very clear about what they're saying. There's no equivocating. The jury can clearly understand that this might have gone too far. But there are sort of weaknesses in their testimony. And by that, I mean, they were not at the scene. What you can see in the cross-examination by Nelson of these witnesses is that he's focusing on judgments at the scene. In these types of cases where you have police officers as defendants, we know that in the past, a winning tactic is to ask the jury to put themselves into the shoes of the police officers because they do not like to do that. So what he's doing is he's arguing that at the scene, in those moments, they made certain decisions. And that's where he was going with the cross-examination, and neither of those officers were at the scene. So that's the only weakness I saw in their testimony.
Julie, did Nelson help with the situation on cross, or what's your thought?
My thought is I think Eric Nelson should use the long weekend to take in the testimony, go back through his notes, and then regroup and commit to a stronger legal theory. Because I think after seeing this testimony from the lieutenant, coupled with the testimony yesterday from the sergeant, I don't think use of force is a really viable legal theory to why the defense should win the case. And so I think their best shot at winning this is by going with the cause of death challenge, challenging it by the underlying health conditions, challenging it by the fentanyl ingestion, reminding people just how powerful and potent a drug fentanyl is. I think many Americans, if you haven't been around it, used it, or know somebody close to you has been affected by it, they may not understand. So my best thought for Eric Nelson is to regroup, commit to a different legal theory, because I think that with this testimony, and this is just the groundwork. I mean, these are the building blocks, right, for the better expert testimony that's going to be coming in from actual use of force experts. These gentlemen have experience, but they're not qualified experts. So there's a difference, but the state did a beautiful job really laying that foundation. And
Hey, Julie, to that end, can I ask you a quick question? Because
Sure.
I'm confused and I haven't seen you in the office yet. I was wondering why they were able to testify that way without being qualified as experts.
Especially what
thought
they
could
order.
have- I thought they could have testified overall about their general experience and learning and what they thought about certain situations. But he asked them specifically about what they saw on that body camera. I was surprised by that.
Right. And that's a really good question. And I think sometimes it tends to get convoluted. I was having that conversation with another colleague in the newsroom this morning. And so make no mistake, when someone is qualified as an expert, there's a process. The legal term is called tendering, when you tender an expert. So you have to go through their long list of qualifications, explain why they can give an opinion. And an expert doesn't have to be involved with the case whatsoever. You get experts from all across the country flying in, and they can be asked about even hypotheticals. They can give an opinion to the ultimate issue in the case. So big difference between somebody with experience. Any lay witness can, reasonably so, depending on if it's relevant or not, but in this case it surely is, they can testify to their life experiences, so what they know about their training, their experience on the job in handling those officers they supervise. All of that, fair game. Just like with Donald Williams, same thing. He has life experience as an MMA fighter, as a wrestler, so that stuff can come in. But they're technically not a qualified expert. And you'll notice there's a process, and when someone is offered as an expert, the other side gets to do a voir dire and ask them lots of questions and essentially challenge their expertise before the court. So we haven't seen that yet in any case, but really good question, my friend.
Chanley, in this case, though, there was a motion. This was litigated, and this was a surprise on some level.
Yeah, it was. There was a motion in limine. We watched the attorneys argue it before the judge a couple of weeks ago during jury selection. The judge issued a written ruling on his decision for the defense motion. The defense moved the court for an order precluding witness police officers from speculating or rendering an opinion on how they would have handled the arrest of Floyd differently. That was granted by this judge, except for the use of force experts, which we expect to hear from at some point. But even with those experts, they have to lay the appropriate foundation and have explicit permission from the judge after a sidebar conference to elicit those sort of opinions, because they do tend to go to the ultimate issue of the case, which is for the jury to decide whether or not this was excessive use of force. And it's also an issue between, yes, we're going to hear from even the police chief, Arredondo, who's going to talk about the policies in the police department. And he'll probably also be able to go towards whether or not this was right or wrong, like we saw from Lieutenant Zimmerman. But there's a difference, Ted, between violating a policy of your employer and criminal behavior. And I think that needs to be clarified by Eric Nelson.
Good point. Good point. Chanley, quickly, we did get some news on Maurice Hall today that he's got some issues.
He does have some issues. He is currently in custody as of right now, Ted. We're learning that Maurice Hall, he's the passenger again that was in the vehicle with George Floyd on Memorial Day 2020. He was taken into custody March 21st for an outstanding domestic violence warrant by the Redwood County Sheriff's Office, not too far from just neighboring to Hennepin County here. He's actually being held in Hennepin County Detention Center, which is only blocks from where this courtroom is that we're watching. And he has a hearing April 5th on Monday before the court on those issues. Now remember, this happened during jury selection when actually this warrant was issued March 8th. He was arrested March 21st. And remember, we have a motion from his public defender that was put forth saying that he would, if called to the stand, plead or take the Fifth Amendment, and they asked to quash the subpoena for him in this case. There it is right there. Mr. Hall, through undersigned counsel, hereby provides notice to all parties in this matter that if called to testify, he will invoke his Fifth Amendment privilege against self-incrimination. Therefore, counsel for Mr. Hall respectfully removes this court to quash the subpoena. He is on the prosecution's witness list, as well as the other passenger, Shawanda Hill. And so it's yet to be seen if he'll actually be called, but currently in custody.
Yeah, okay. Well, doesn't really have anything to do with this case. Well, now that we're at the end of the week, let's grade the prosecution and the defense. Professor Grant, what would you give the state of Minnesota and Eric Nelson and Chauvin's defense team?
Oh, that's such a good question, Ted. That's tough. I think they're all faring about as well as can be expected. Little things, and it's always easier to watch a trial right when you're not participating. It is stressful. It's like herding cats trying to get your witnesses lined up. It's easy to forget things, and there are a lot of moving parts. So, I think everybody deserves high marks for doing about as best they can in this situation. What I'd like to see more of for both sides is a little more precision in the way they're trying the case and getting to the points a little bit quicker and more succinctly. And I think there's a little bit of time being wasted with a little bit of testimony that isn't necessarily helping further the elements that need to be proven. And I think one reminder, too, as we head to the weekend, the defense doesn't have a burden here. They've got no burden. And I see a lot of people being really critical of the defense on social media and whatnot. And I think sometimes it gets lost that they don't have to put on anything. They don't have to ask a single question, call anyone, but they are. They're being very active. And Eric Nelson has a really, really tough job.
Yes, and doing a great job, in my opinion. Michael Ayala.
Yeah, I agree. I think Eric Nelson gets an A. I think he's doing a great job. He's got a tough case, just as you've noted, as Julie noted, Chanley as well. I mean, it's a difficult situation for him. And I think he has a couple of theories, one of them weaker than the other, clearly. But I think he can't just abandon it. I think he has to go for both, and I think that's what he's doing. I think he has a very clear vision of what his defense is, and he's working the prosecution witnesses to help his theory of the case and doing a great job at that. And the other side, for the prosecution, we were all concerned. There was some suggestion maybe they weren't prepared. There were some issues there. Too many cooks would spoil the brew. But I think they're doing a great job. I think they show that they, too, have a clear sense of what they're doing with this case. They seem organized. Certainly, there could be a little tightened up here and there. But at the end of the day, I think they're both doing pretty well.
Sounds like a couple solid A's there.
Hey, I'm an easy grader, I'm not like Julie.
And Chanley, I assume that from your vantage point, because you've covered a lot of trials, this one, given everything, is running quite well. Both sides.
Absolutely. I mean, it's the prosecution's case in chief, so they have the momentum right now, right? They're the ones calling the witnesses, putting on the evidence, and we've heard from 19 so far, including those 2 officers who really are saying what Chauvin did was wrong in front of this jury. Plus, different angles of video. I think I've counted 6+ different angles of video of the incident before the jury this week, really hammering home what happened. But again, like Michael said, defense taking advantage on cross-examination to go back to their theories of the case. So yeah, I'm with both Julie and Michael.
All right, lots for the jury to think about over this long weekend. Thank you all. We're going to step aside, take a break. We'll be right back after this.